For most people, a first DUI with no injury is a misdemeanor, not a felony. That distinction matters a great deal. A misdemeanor still leaves a mark on your record and carries real consequences, but it sits in a fundamentally different legal category from a felony, and the penalties, while serious, are bounded. Probation, not jail, is where most of the daily impact of a first DUI lies. Vehicle Code 23538 governs the terms. A first offense almost always brings several years of informal probation, with specific conditions you must follow. The one that trips people up most often is the zero alcohol while driving rule. While you are on probation, any measurable amount of alcohol in your system when you drive is a violation. A single drink before driving can be enough to trigger that, and a violation can bring suspended jail time back into play. The financial hit is larger than most people expect. A first DUI carries a base fine under Vehicle Code 23536, but the court layers on a long list of mandatory penalty assessments and fees that multiply that base figure several times over. Separately, nearly every first conviction requires completing a licensed alcohol education program. The length depends on your blood alcohol level, and it is a real months-long commitment, not a one-day class. A first DUI triggers two separate suspensions, one administrative, handled by the DMV, and one tied to any court conviction. The administrative suspension for a first offense is generally 4 months. For many first offenders, installing an ignition interlock device is the fastest path to keeping full driving privileges, sometimes almost immediately during the suspension period. The IID is an added cost and obligation, but on a first offense it is generally a choice, not a mandate. If you prefer not to install one, a more limited restricted license is typically available instead. Not every first DUI lands in the same place. Several facts can push yours toward the harsher end of the range. A high blood alcohol level, a refusal to test, an accident, excessive speed, or a passenger under 14 in the car can each add enhancements or stricter conditions. Knowing whether any of those apply to your situation changes the realistic picture and shapes the strategy for keeping consequences as low as possible. The penalties described here are a starting point, not a predetermined sentence. The charge level, the probation terms, and even whether you end up with a DUI conviction at all depend heavily on how the case is handled. A reduction to a wet reckless, where the evidence supports it, can soften nearly every consequence. And a clean resolution on a first offense protects you if there is ever a future case, because a first conviction becomes a prior that escalates everything that follows. Results vary and there is no promised result, but these cases are worth examining carefully. A first DUI is serious, but it is also the case where a strong defense can make the most difference. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.